What is a substantial change in circumstances in an Illinois divorce? When an Illinois divorce decree is entered, final orders address property division, support and parenting. Life keeps moving, and courts must decide if a substantial change in circumstances justifies revisiting those orders. Chicago divorce lawyer and divorce attorney Russell D. Knight of the law office of Russell D. Knight, whose law firm produces plain English articles on Illinois family law, notes that ongoing support and parenting orders can be revised when circumstances change. Modifying parenting and responsibilities. Parenting schedules can be adjusted at any time for the child's best interests, and the law speaks of changed circumstances rather than substantial. Courts look at all circumstances when a parent seeks a new schedule. Decision-making authority is harder to modify. Parents generally must wait 2 years before seeking a change and must show a substantial change in circumstances. The modification must still serve the child's best interests. Modifying child support. Both parents are financially responsible for their children. A support order can usually be changed only when a substantial change in circumstances shows that the child's needs or the paying parent's ability have changed, and the party seeking modification must prove it. A significant difference between the proposed and current amount can also justify modification. Small income increases do not meet the standard, and courts look at parents' and children's finances. Modifying maintenance. Maintenance, once called alimony, is calculated so that the recipient's share does not exceed 40% of the combined net incomes and may be modified or terminated only upon a substantial change in circumstances. The change may involve the receiving spouse's needs or the payer's ability to pay, and courts look at employment, earning capacity and property. A 25% shift in income is often treated as substantial. Defining a substantial change. There is no precise formula for what constitutes a substantial change, and the party seeking modification bears the burden of proof. Legislative amendments do not, by themselves, constitute a substantial change, and a change affecting only a parent is insufficient. Parties may specify in agreements that certain events will not qualify. What counts and what does not. As children grow from toddlers to adolescence, their changing needs can justify adjusting parenting time. Minor income fluctuations are disregarded, while shifts in employment, earning capacity or property matter. Legislative changes and parent-only changes do not meet the threshold. Illinois courts generally require a substantial change before modifying divorce orders. Parenting time can be adjusted with any change that serves the child's best interests, while decision-making, support and maintenance modifications hinge on a proven substantial change. There is no single formula, and courts retain discretion even when a change is shown. For guidance tailored to your circumstances, contact the law office of Russell D. Knight at 1165 North Clark Street, number 700, Chicago, Illinois, 60610. Or call 773-334-6311 to speak with a divorce lawyer or attorney at this law firm.